Texas just rewrote the rules on abortion, and it's not stopping there. Senate Bill 2880 doesn't just ban pills. It targets your posts, your inbox, even your voice. This isn't policy. It's a power play, and no one is off limits. Welcome to the new front line in America's abortion war. In a political plot twist, hotter than a Texas summer, the state Senate just pulled off a unanimous stunner on one of America's most divisive issues that on April 29, 2025. The Texas Senate bill passed 31-0 in the GOP-controlled Senate and would specify that doctors can perform abortions if a patient faces a life-threatening condition capable of causing death, not necessarily one actively injuring the patient. It also mandates training for doctors on the revised law. This would be the first modification to Texas's near-total abortion ban since it took effect after the Supreme Court overturned Roe v. Wade in 2022. According to an AP report, Republican State Senator Brian Hughes, an architect of the original ban, said the changes aim to remove any doubt so doctors can act when a mother's life is at risk. We know there are cases where moms who should have been treated were denied treatment. We've learned in a number of cases where the physician was willing to treat the mom, but the lawyers for the hospital would advise against it. I introduced the bill to remove any doubt that doctors can perform an abortion when a mother's life is at risk. Despite the bill's support, it still excludes exceptions for rape or incest and does not list specific medical exceptions, a point noted by Democrats who nonetheless backed it. Predicting it will save lives, Democratic State Senator Sarah Eckert called the policy no less cruel for being made clear. Women previously denied abortions despite life-threatening complications have cautiously welcomed the changes as a step forward. I will vote for it, but this policy is no less cruel for being made clear. The legislation responds to years of challenges and criticism that abortion laws in Texas are too vague regarding what constitutes a life-threatening condition. The Texas Supreme Court ruled in 2024 that the state's abortion laws were not too vague, rejecting challenges from women denied abortions. Physicians face up to 99 years in prison and fines for illegal abortions. If passed by the House and signed by Governor Greg Abbott, the bill would improve medical care standards while maintaining Texas's restrictive abortion framework. Texas lawmakers are sharpening their knives not just against abortion, but against your right to speak, share, and know. Senate Bill 2818 is the state's latest attempt to scrub the internet clean of any trace of abortion information, as reported by the Electronic Frontier Foundation. Under this bill, it wouldn't just be illegal to get abortion pills. It could be illegal to talk about them, write a blog about out-of-state options, post on social media about where to find medication, email a friend who needs help. Under SB 2880, all of that can make you a target. The report further claims that it doesn't stop at individuals. The bill goes after platforms, social media websites, email providers for merely hosting abortion-related content. And just like SB 8, it empowers private citizens to file lawsuits, the result silenced through fear. Platforms are given absolute immunity if they block access to abortion-related info, encouraging preemptive censorship. Though the bill insists it won't violate the First Amendment or conflict with Section 230, it is largely a hollow promise that SB 2080 isn't just a speech suppression bill. It's a legal sledgehammer aimed at reproductive autonomy, recently passed in the Texas Senate. The bill greenlights $100,000 lawsuits against anyone who manufactures, mails, or delivers abortion pills into the state. That includes pharmaceutical companies, online pharmacies, even postal workers. This is a strong statement about these pills and their harm to little babies and to women. It's strong, declared Republican son Brian Hughes, the bill's author. And he means it. The bill empowers private citizens to sue. Even judges who rule the law unconstitutional could be slapped with six-figure penalties and denied representation by the state attorney general. That's not enforcement. It's judicial intimidation. These are the pills that are being mailed into Texas directly to women, often without instructions, certainly without doctors as before, and without follow-up care after. This is illegal in Texas, but it's taking place, and we've thus far not been able to protect women. Ignoring the law is not very nice when the legislature specifically sets it out in a way that's clear and unequivocal. The intent is to be a very strong and unequivocal statement to those who would ship these pills into Texas that don't do that. This is a strong statement about these pills and their harm to little babies and to women. It's strong. Democratic Senator Nathan Johnson warned that the bill is a flagrant, brazen transgression of America's legal foundations. It's a flagrant, brazen transgression of the principles on which this country and state was founded. If there is a judge who is having to defend herself or himself under this provision, they may not receive or obtain legal representation from the Attorney General. Now, that's not very nice, is it? While supporters of SB 28 argue it's a necessary measure to enforce Texas's abortion laws and protect women's health, critics warn it sets a dangerous precedent, blurring the lines between enforcement and overreach. As the bill moves forward, it raises urgent legal and ethical questions about the balance between state authority, individual rights, and the role of the courts in safeguarding constitutional protections.